This is TWiT.
So anybody who is listening and is a lawyer and is a litigator is probably not too surprised that on the morning of what would have been their 5th day of trial, Uber and Waymo, aka owned by Alphabet, aka Google, have settled their case. This kind of thing happens quite frequently, even when the parties have tons at stake and it seems like they're never going to settle. Once trial starts, things can change. And I think that's what we're seeing play out here. The terms of the settlement, well, we don't, I think, know the full terms of the settlement, but Uber has agreed to pay Alphabet the equivalent of $245 million in equity. They also have agreed to give Alphabet a 0.34% interest of Uber's latest funding series. So they're both spinning this as they are now partners rather than adversaries. Uber has made some representations that it will never, ever in a million years use Waymo's, it doesn't actually say in a million years, never, ever, but that they're not going to use Waymo's intellectual property now or into the future. So you could interpret that as never, ever in a million years. I would say that's specific legalese that could be incorporated into the agreement. And the claims are being dismissed with prejudice. They are not going to be refiled. So, Mike, we've all been playing along with the trial this week. Were you, like me, unsurprised to see a settlement drop down on us?
Well, yes and no. I mean, I agree with you that this does happen. And it's not an infrequent occurrence by any means that both sides, see how it's happened to me on one occasion. We settled a case midway through. Hard to know exactly why the parties decided to lay down their arms and as you said, hop into bed together. I mean, it could be that the evidence that one side thought was going to be great maybe fell flat as far as they could tell. Maybe they weren't thrilled with some of the rulings that the judge made. Hard to know for sure. We do know that I think I've got these figures right. Initially, I think Google was looking for close to $2 billion. And then that went down to $1 billion. My understanding is I read a report that there was a settlement offer earlier in the week made for $500 million. And then last night at the close of testimony, it sounds like they started talking about this $244 million or the equivalent thereof. And so that was enough for Uber. So it's fascinating. I'm a little bit saddened that we're not going to see how this ultimately played out and what the jury was going to decide. But this is I think a reminder for both large and small companies alike that when it comes to particularly to technology companies, when you're dealing with digital property and related IP, the due diligence that's necessary, it's paramount to make sure that former employees that have left the employ of a company, that they're thoroughly vetted. You make sure that they're not bringing any IP that could get the acquiring company into trouble. You got to look at when you're acquiring a company to make sure to trace the origins of that company's IP to make sure that you can account for its origins and where it came from, and that company is not going to be tainted with a claim of misappropriation. So it was a fascinating case. I mean, we loved talking about it before on the podcast here. We loved following the case, seeing all the twists and turns. I mean, it was high drama there in San Francisco. And, there was just so many interesting, delicious moments throughout the litigation. I am, like I said, a little bummed that we're not going to see how this ultimately played out.
Well, it certainly has been great to play along with the people who were reporting live from court this week. There have been some amazingly entertaining and dramatic moments. This morning, had the parties not settled, Anthony Lewandowski, the owner of the company that Uber acquired, that allegedly had the trade secrets that came from Waymo and Alphabet, was about to take the stand, or he would have been called to the stand as part of the conclusion of Waymo's case in chief, but he would have taken the Fifth Amendment. So that would have been dramatic. And we didn't get to see that play out. The jury did get to be played. Judge Alsup allowed to be let in a clip from the movie Wall Street, the famous Greed is Good case, which became relevant in the case because of communications between Travis Kalanick and Anthony Lewandowski, and their communications. Just sort of looking at their communications under a microscope was a huge part of this case, and trying to read into the sort of cryptic comments they would make to each other in text or emails, what have you.
Right.
What that meant, whether Travis was telling Anthony to steal trade secrets or not. I think that was a big part of what would have been at stake as this case went on. Any sort of, you were starting to do this, Mike, give some sort of cautionary tales and lessons for future businesses that we can take away from this dispute. Is there anything you want to say about those communications? And certainly a lawyer can't vet every single thing that is going back and forth in the course of negotiating the purchase of a company, which is what was happening here. But it seems like it would have been nice if there had been more oversight.
Yeah, I think that's exactly right. And I think Uber, although it hasn't come out and said that exactly, I think one of the quotes I read is that they wish they would have done things a little differently, which I think is probably a fair statement, and maybe an understatement of the year, that they should have done things a little differently. Yeah, the text messages back and forth between the CEO and Lewandowski. I mean, some of those were, and I'm somewhat paraphrasing here, we better burn the village, was the response. Yep. So it's like, okay, what exactly does that mean? A lawyer on the other side could probably have quite a field day with an exchange like that. But yeah, I mean, I think this is the poster child for the scenario where it can be very difficult to get your arms around, former employees' communications with the CEO. I mean, you got to just be super vigilant and very diligent here. There, as I understand it, there was some report that was that Uber had commissioned from a third party that looked into whether trade secrets or other information may have left Google when Lewandowski left, and I believe this third party came back and said yes, there was some material that was taken. Interestingly enough, when the Uber CEO, or I guess the former CEO of Uber, testified during the trial, he was unaware of this particular report that was issued by this third party. So, yeah, I mean, it's. I think there's a lot of different takeaways, but probably the main one is, look, you just got to make sure that you've got a great team that's analyzing the situation here, and that you're kind of covering all your bases in the acquisition process.
The other thing I'll add to my being unsurprised about the settlement 5 days into trial is I don't think there were legal issues at stake here that either party wanted to establish precedent for. This was a very factually driven case, whether trade secrets were stolen or not. And I don't think that there were any sort of wrinkles in how the trade secret law was going to be applied or interpreted by the court that, say, Alphabet had a huge stake in making sure the case came out the right way and pursuing it all the way through an appellate process, or same thing for Uber. Do you agree, Mike?
I think that's probably right. Things were a little bit opaque here because this was a trade secret case. we don't have visibility into exactly what the trade secrets were. And at times during the trial, the courtroom was cleared so that testimony could be provided with respect to what the trade secrets were at issue. So I think that I think your sense is probably correct. I think the biggest issue here, and from not only my understanding of the case, but also reading some of the commentary from people that were actually in the trial, is even though there seemed to be like a lot of smoke here with respect to what Lewandowski did and his departure from the company and starting Moto, the other company that was ultimately purchased by Uber. One of the comments or stories I read was, look, there's a lot of smoke here, but I'm not sure that there's a lot of fire that they've been able to establish yet that Uber actually misappropriated or knowingly took information that it shouldn't have taken. I don't know if that's an accurate assessment of the case, but I think your sentiment is probably right.
Rob, you are the closest geographically to ground zero of this case. What's the scuttlebutt about this in the Bay Area?
Yeah. Oh my goodness. Just the Schadenfreude of this is so delicious. It's hard to get past that to any sort of real legal question. I think that, talking about cautionary tales here, one of the articles that I think we have in the rundown here about, decoding Travis's kind of bro speak that he uses with the employees and how this like very hyperbolic language has become such a part of tech and sort of the conversation. I mean, obviously shows like Silicon Valley do a wonderful job of parodying, the save the world rhetoric and the, sort of the tech jargon. But there's a lot of this like very aggressive burn the village, mastermind some shit, all this stuff that he throws around, and that did not pay out well for. I mean, I was about to say it doesn't play out well for them. I guess it did play out well because of ultimately how the trial resolved. But I think there's a lesson in that for any time. In trade secret cases or just in communications with new employees, particularly in, say, an acqui-hire situation like this. I mean, speaking like a responsible adult, if you're a CEO, has real benefit. I mean, because a lot of what this case was about the impression that there was something, potentially even criminal going on here, that and a lot of that has to do with just the language that they were using back and forth with each other. And that may be fun and that may be part of what, sort of the culture that you want to create for your company. And certainly Uber has any number of cultural issues that they need to work through generally. But I think that that's a real takeaway for this and really for trade secret litigation generally is that, if it looks like something untoward is going on, that's going to get you a lot further down the litigation road than if it looks like the parties are behaving reasonably. And particularly because it's a tough question. What is a trade secret? What is, general know-how that might come in the head of the person that you're hiring away from a competitor? And, these are tricky questions that are hard to litigate. But I think, looking like you're trying to be respectable and not, wanting a pound of flesh or whatever the heck it was he was saying, probably best for your CEO not to speak that way.